My distinguished sister and brother judges and colleagues of the Supreme Court, Shri Vikas Singh, President of the Supreme Court Bar Association, our distinguished Attorney General, Mr. R. Venkatramani, the learned Solicitor General, Mr. Tushar Mehta, Mr. Pradeep Kumar Rai, Mr. Rahul Kaushik, distinguished senior members of the bar, and all the other members of the bar who are present here. I'm really deeply grateful to you for organizing this felicitation event on my being appointed as Chief Justice of India. This has a very special significance for me because I commenced my practice as a young member of the bar in the Supreme Court. My father had made an announcement that I will not join the bar and be in active practice so long as he was the Chief Justice of India, because he believed that wherever I joined, that court in that sense would be below the Supreme Court in hierarchy, which is what led me to 3 years of graduate education in the US, after which I returned. But on my return with an LLM and a PhD, an SJD as they called it at Harvard, I realized how uninitiated I was in the law. When I went to Mumbai, my first brief was given to me by a good friend to mention a matter before Justice Sujata Manohar. Then I asked him, I said, how much should I mark on the docket? Because you have these green dockets where you mark your fees in gold mohars in Mumbai. Each gold mohar is 15 rupees as opposed to Calcutta where I believe it is 16 rupees. I thought I would be given a reasonable fee commensurate with my educational qualifications. But he told me that, well, ordinarily, a junior is paid 5 guineas for mentioning a matter. In your case, since you are being briefed for the first time by me, you can increase it to 6 guineas. So I had a fee of, a very, very royal fee of less than 100 rupees to mention a matter. That's where I began from. But I realized when I came to the Supreme Court to practice how uninitiated I was in the law. But I really learned my craft at the feet of the greats of our own bar and on the bench in those days, to whom I have an eternal debt of gratitude. One of my first briefs was given to me by Mr. Praveen Parekh from Parekh and Company to appear in a land acquisition matter before Justice M.P. Thakkar. I had not the faintest clue on how to argue a land acquisition matter, no clue about what sale instances are all about, and least of all was I aware of something called the Miriam's tables, which formed the basis. It was like an actuarial table in that case. So Justice Thakkar kept the matter the next day and said, don't sleep in the night, but get ready with the brief and come and argue the matter tomorrow. And that became reported as Chimanlal Hargovindas versus State of Gujarat, on the basis of which I got several more matters. People didn't realize that the real credit for that judgment went to the judge and not to the lawyer, the young lawyer who was arguing the matter. So I really learned at the feet of the greats of the bar and the bench. I was briefed with Mr. Fali Nariman in a matter relating to the withdrawal of the prosecution of 3 chief ministers under section 321 of the CRPC. And that was challenged and eventually referred to the Constitution bench. So when the judges were exchanging a conversation between themselves, I was keen to tell the senior on what is the next line of authority to cite. So he put his hand up and said, quiet, he said, quiet. And then he told me, he said, when the judges speak, when a matter is going on, focus on the court and focus on what the judges are speaking about. Then in numerous conferences, I learned what we have now called, we have come to learn or label as the Nariman list of dates. Every time you had a conference, you would improve upon the list of dates. The dates would be distinguished from your submissions, which would come in the form of a note. There was Lal Narayan Sinha ji, the then Attorney General, who was understated brilliance personified. You could barely hear him behind the first row. But when you leant over and tried to follow what he was arguing, you were struck by the sheer brilliance in his simplicity, in the manner in which he made his presentation. You recall that he was the Attorney General who walked out of the court when Ram and Shaman was being argued, that famous case on tenders. I was in the court when Mr. S.N. Kakkar was arguing a matter in court number 4, when a very strong judge, Justice D.A. Desai, was tearing a young junior apart. And Mr. Kakkar was pouring into his briefs, getting ready with his own case. And then suddenly he sprung out of nowhere and said, "My lords, I protest at the manner in which the junior counsel is being dealt with by your lordships. And if I don't raise my voice, I would be unfair to the young juniors for whom I stand today." There was Mr. K. Parasaran. We would spend hours when he used to argue before the Constitution bench. The court was not, court number 1, the Chief's court was not as crowded in those days. So we would spend post-lunch sessions on days when Mr. Parasaran was arguing a Constitution bench matter and just listen to him expounding for 2 hours the bare text of the Constitution, not a single authority in hand, but just the Constitution in his hand, arguing from the legislative lists, explaining to the court how the legislative lists had to be balanced. I was once arranging books in the lunch tower in court number 1 when the irrepressible Mr. R.K. Garg walked in and gave me a slap on my back and said, "What are you doing? Haven't you had your lunch?" So I said, "I'm arranging the briefs for my senior." He says, "That's the problem with you Bombay lawyers. You only focus on efficiency. But where will the vision come from if you only focus on your cases? So look beyond the immediate brief that you are called upon to argue." Then, of course, you had Mr. Soli Sorabji, with whom I appeared in so many different cases. Precision, the vision of public law. He led me in D.C. Wadhwa versus the state of Bihar, the matter which went to the Constitution bench when the Bihar Ordinance Raj was challenged. And it all arose from a book which was written by an economist who was researching land tenures in the state of Bihar. And he found that ordinances were being repromulgated for 10 years, 12 years, 15 years without being converted into law. And that became the subject matter of a challenge which was really spearheaded by Mr. Sorabji, and that was the brilliant judgment of our court. There was Mr. Ashok Desai, who would talk to you about law, but he had a deep connect between law, life, and literature. I remember as a very young lawyer, I had gone to him on a Saturday to brief him. So after the conference was over, he asked me, so he said, "Young man, what is your poison?" And to which I answered in a very ignorant way. So I said, "I haven't yet decided to consume any, sir. I haven't come to the stage when I have to really look for poison," only to be told later on that poison meant something very else, something very different in the analogy of Ashok Bhai. Dr. Chitle, about whom the Attorney General mentioned, Dr. Chitle never left the chamber even after work was over. He had a stipulated time to leave the chamber, which was typically at 10 o'clock in the night. So when the conferences were over, and many of those conferences were occupied by a very young Mr. R. Venkatramani, so very earnest and always on punctual time, he would just pick out a book from the library, whether it was the Restatement of Laws or American Jurisprudence or some book on the law, but never left until it was 10 o'clock and it was time to reach. And that's how the classical judgment in Central Inland Water Transport Corporation came into being. I was briefed once with Mr. Ashok Sen, and he said that, "I have no time for a conference, but if you don't mind, will you accompany me to the airport in my to research over the weekend?" So between the Supreme Court and Palam, I was occupied by just the sheer brilliance of Mr. Ashok Sen, who through his memory would throw cases at me and say, "Look, this is the citation, look at these cases, and be ready for me when I come back on Monday morning to argue the matter."